C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just gonna stop submitting you to drug testing. I'm not gonna do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye.
Situation all over again. I'm just like, all right. Can I see Beth Nicole Martinez? I believe there is a motion to revoke.
There is.
There is. All right, can I have a file stamp, please? Court is calling 2021 CR 8476 State versus Beth Nicole Martinez. Can I have parties announced?
Ashley Jones for the state.
Robert Porter for Miss Martinez.
Are you Ms. Martinez?
Yes, ma'am.
All right, did you review, and counsel, you have 10 days to prepare. Are you ready to proceed?
We are.
All right. And Ms. Martinez, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Beth Nicole Martinez who's placed on deferred adjudication in 2021 CR 8476 for the offense of aggravated assault with a deadly weapon on October 12, 2021 for a period of 4 years? Is that you?
Yes.
All right, state.
Yes, state's going to proceed on violation of condition number 2 on or about the 7th day of October 2024 in Bexar County, Texas. The defendant, Beth Nicole Martinez, did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
The state will waive the remaining violations.
No objection.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court will find violation of condition number 2 true. Is there proposed agreement?
Partially, Your Honor, the agreement was for her to plead true to violation of condition number 2. I do believe defense and I both have different recommendations. The state's recommendation is that she receive some sort of inpatient treatment given the positive UA and the failures to submit. But I do not see any evidence of mental health directives. I mean, the only thing we have is going back as far as 2021. I don't have anything current on that to show that there's DPRF.
It's my understanding, Judge, and I think the state checked into this also. Felony drug court, she was in phase 5. They checked into that. What that is, that's the aftercare program. If the court takes notice, the last drug test was back, I want to say 30 UA, it was either September or October, the October one. We don't know if she's pregnant or not. She may have miscarried. They will find out this week. Having said that, Judge, we would like some form of outpatient treatment, maybe weekly UAs. It's like like I told the state, you're running the 440-yard dash, you make it to 435 yards, and then we don't quite complete it up. Now we're gonna have to start another 9-month program. At the time this happened, her father had just passed away from cancer. She was trying to take care of the estate and stay in his house. It became overwhelming for her at that point in time. I think that's where she got off track.
I actually did ask them for help. I asked them if I could ask alumni for help with my father's funeral. I even asked if I could put his fundraiser out there. And the case manager at the time, CJ, denied it. She didn't even let me bring it up to alumni.
But now here's the thing, it's not about whether or not you can do a fundraiser. It's about, I'm struggling because I have all of this hitting me at once. I'm struggling in the sense that I may not do my UAs. I may fall out of this program. That's what it's about. It's not, I'm struggling. I've asked you for A, B, and C, and your answer is no, I'm not doing A, B, and C. So therefore, I'm just gonna stop submitting you to drug testing. I'm not gonna do any of this.
I actually even did ask my judge if he can move me case managers because we weren't seeing eye to eye. I didn't get that, and I tried to work with my case manager. I did good the whole time I was on it.
So let me ask you this. Here's the question. You asked for your case manager. You tried to work with your case manager and it wasn't working. So your response to that was to do what with your probation?
I'm at with this one. I had too much stuff going on. I was losing
Right,
my
so
father's house.
your decision with probation was what? With felony drug court? See, I'm trying to get you to point, cause see,
Well, I know where I messed up. I'm not saying I didn't.
yeah, but so that's the thing. You didn't learn anything from felony drug court, because let me just explain something to you. Everybody in this court has a bad day. Now, some may have a bad day that is not as bad as others. Let me just tell you what happened to me. I had a client who was on parole. I had a parole hearing scheduled for them. You can unfold your arms. I had a parole hearing scheduled for them. I knew that they had mental health issues, and I knew that they were depending on me to be there for their parole hearing. All right, so I'm sleeping, everything's going well. I get a call at 3 a.m. It's a Monday. I get a call at 3 a.m. And you know what that call is? It's from my younger brother. And guess what he tells me? Grandmother died. Now, what do I do in that situation? I know I got a client who's expecting me, who has mental health issues, who maybe won't understand. I know I'm an attorney for children on CPS cases who are not going to understand. So do I just throw my hands up and say, you know what? This is what's going on in my life. I'm not calling anybody. I'm not doing anything. You all handle it. See you later. It's called adulting and growing up. So what did I do? My mom, of course, was upset. She's like telling my brother, why did you call her? You know, it's late. She's far away. She's all the way in another state. But I went and I did the parole hearing because that person was depending on me. I went and visited children because they were depending on me. And then I got a flight and left for home. And I left messages to everybody, hey, my grandmother just died. I'm gonna have to go home. So I tell you that to say everybody has problems in this world, but your problems in this world, you're supposed to be able to deal with that. And dealing with that when you're looking at 20 years in prison is to, when somebody says, no, we're not gonna do that, then you gotta accept that. You're on paper. That's what we called it when I was defense attorney. You're on paper, you're looking at 20 years. So here's my question. Is the TAP evaluation updated or no?
Your Honor, the TAP evaluation I have from probation is from 2021. I do not see, I don't have any information.
All right, so we need an updated TAP evaluation. So I'll find number 2 true. I'm gonna give you a choice. I can deny the motion. You're not getting out of jail today. You're gonna do the TAP evaluation in custody. If the TAP evaluation says you're going to inpatient, you're going to inpatient. Or what I can do is I can revoke you and I'll give you 3 years. Those are your choices.
And how long does the TAP evaluation take?
It won't be long. I think that's the right choice.
Will I get my back time if I sign up?
Sure. All right. We're back on the record. Yes. So what do you want to do?
Do the TAP evaluation.
All right. So the court will deny the motion, alter and amend conditions to include in custody. There's to be a TAP evaluation, follow all recommendations. And there's also to be an updated MIC evaluation in custody. And is there anything else that's being requested, State?
Oh, yeah.
And is there anything else you need from the court, Miss? Is there anything else you need from the court?
No, ma'am.
All right, and there's to be no residents with minors. All right, thank you.
Thank you, Judge.
You're welcome.
Nathan Valley cases.
Yes. Court is calling 2024 CR 011095 State versus Luis Okura. Can I have parties announced for the record?
Andrew Harris, I don't.
Hector Garza Jr. for the defense.
And are you Mr. Okura?
Yes, Your Honor.
Just 1 second. Counsel, have you received all discovery and did you review it with your client?
We have.
Court will find that the state is in compliance with discovery. Is there an application in this case?
There is.
Did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do wait.
Are you proceeding on the indictment as presented?
No, Your Honor.
Any objection?
No objection from the defense.
Mr. Okura, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand, in count 1, you're charged with the offense of aggravated assault with a deadly weapon? That's a 2nd-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel that he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel that he is and was.
Mr. Okora, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at a cap of 6 years in the prison. There's a $2,000 fine. State is silent on your application. They're taking consideration night mag number 760070. There's to be restitution and no contact to the complainants. Did you understand that to be the plea?
Yes, Your Honor.
And did you understand if the court were to determine that there is a weapon used, the court would make an affirmative finding of a deadly weapon? All right, defense, is that the plea?
It is.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there many such motions?
There has not.
Then to count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections from the defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Honor. Yes, Your
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to set this for a PSI, it'll be 8 weeks. But if you would like, what we can do is I can reset it for a sentencing and you can bring in whatever witnesses you would like to bring in. And I'll ask the state for his criminal history. So which would you prefer?
We're gonna bring in several witnesses, Judge.
All right, so are you waiving the PSI then?
Sure.
All right, so what date would be good for you, counsel?
I would like to look towards April, Judge, just to make sure that we can coordinate with the individuals. At this point, I have the 22nd or the 23rd available.
I can do it the first week in April.
I am in Del Rio and then Eagle Pass, 3 days of the week, so I'll be out from Monday through Thursday.
Mhm.
The following week, the earliest I would be able to do is the 10th.
All right, Ms. Ferguson, if you'll put this for April 10th for sentencing and the PSI is waived. And we can go off the record, what ended up happening, the state is silent on your application. The only thing I'm gonna need from them is your criminal history, if you have any.
There we go.
And then I will hear whatever witnesses or evidence your attorney wants to present to the court. And then I'll make my decision on your application based upon any evidence that I hear or receive, okay? Do you have any questions about anything? All right, once you sign the reset form, you'll be excused. Just have a seat and your attorney will bring it to you.
Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
Yeah, it's good.
Hello, Ms. Martinez. All right, so what is the update on the evaluation?
2 weeks ago, she was found incompetent. We should be going back again to that court. She wanted to order some other testing because it was believed, and after she's done with her treatment, that she will become competent. That'll take a while. So that's where we're at right now. And I think we got another hearing this week to discuss the other testing that the state was smart to give her some more evaluations to try to help her understand her problems better, as well as the people that are treating her.
All right, Norma, set this for the fourth week in May, please. Isn't that a holiday?
Why not?
All right, May 27th.
Oh, excuse me.
All right, we're gonna bring you back to this court on May 27th. We can't go forward on anything until a doctor states that you are currently competent, okay? Do you have any questions?
For Cordova,
I'm sorry, you have what?
for Cordova, because something that I was trespassing and that I had spit on his mouth, which is I didn't. I had a.
All right, so
wipe
let
on
me,
the mouth.
so let me
I did it
explain.
already 3 times.
So it's probably best for
Fourth time.
you not to speak about your case. All right, so, and I just say that for your protection, because your attorney may have different defenses that he wants to put forth in the court. But what I can tell you is, until I get something from the magistrate's court saying that you're competent, I can't move forward or do anything with this case. You understand?
Okay.
All right. All right, thank you so much.
Thank you, Your Honor.
You're welcome.
And I'd be excused.
Yes, you may be excused.
Thank you, Your Honor.
Mr. Sullivan, you still have another client.
Oh, I do?
Yes, he's gonna go and get him.
Melissa
He's gonna
Johnson.
go and get
If you
him.
can put her up.
Okay.
Thank you.
Get it off.
Oh.
Yes, he can. Now, can you go to the second one?
All right, this is contested, correct?
We're gonna put you to the number 5, Judge, the felony report.
Right. Court is calling 2020 CR 11653, State of Texas versus Corlissa Denora Johnson. Could I have parties announced for the record for the state
Ashley Jones for the state.
defense?
Jim Wheat,
And are you Miss Johnson?
Yes, ma'am.
Your Honor, I'm sorry. I don't know.
Sure. If y'all want to step back and confer, you can.
Please, Judge.
All right, just have a seat and I'll call you up when they're ready. Who are the attorneys of Matthew Salazar?
Hi, guys. Ready?
State, are you ready?
Yes, Your Honor.
Okay.
I do.
I'll give it.
My notes are on that. Okay,
If you want to give him that back, I can give you mine.
that's fine. She can.
All right. All right, court is calling 2022 CR 3264, State versus Matthew Salazar. Excuse me, guys, we're on the record. You need to ask the deputy to move you down there. State versus Matthew Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Robert Porter for Mr. Salazar.
And are you Mr. Salazar? Are you the same Matthew Salazar who was placed on community supervision in 2022 CR 3264 for the offense of assault of a pregnant person on December 8, 2022 for a term of 10 years? Is that you?
Yes, ma'am.
All right. State,
State is moving forward on violation of condition Salazar. That then and there fail to apply for, provide documentation of attendance and comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following program, battery and intervention and prevention program in violation of condition number 14G.
how do you plead to that? True or not true?
True, yes, ma'am.
All right, state,
Violation of condition number 39 on or about the 19th day of April 2024 in Bear County, Texas. The defendant Matthew Salazar did then and there fail to submit to an evaluation for placement into the drug court in violation of condition number 39.
how do you plead to that? True or not true?
True, yes, ma'am.
Violation of condition number 42 on or about the 7th day of August 2024 in Bear County, Texas. The defendant, Matthew Salazar, did then and there fail to submit to a substance abuse evaluation with the Bear County CSCD's treatment alternative to imprisonment.
How do you plead to that? True or not true?
True.
The state will waive all
No.
violations.
No objections.
Did you understand by pleading true to violation of conditions 14G, 39, and 42, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to 14G, 39, and 42? Court will find 14G, 39, and 42 true. Oh, did you all fill out an application, a trial court certification?
Well, he's on probation, so that one should have been one already filled out.
That's okay.
My apologies, Jeff.
Yeah. Well, you know what?
Nice as
They
that.
ran out of paper,
Hmm.
you know, the regular one, so this is what they've given us. All right, is there a proposed agreement?
There is not, Your Honor. We had a partial agreement to plead true to those conditions, so they are not contested, and to waive the other condition, violations. And then I believe we're going open to the court with the recommendation of the state and the defense's argument for their position.
All right, so are there any witnesses?
No, you don't.
All right, state, what are you requesting?
Your Honor, just given the seriousness of the offense for which the defendant was placed on probation for, he did receive 10 years, probated for 10 years, so he is subject to the underlying sentence for 10 years. For, I do believe he's been on probation since 2022, and he has not done the Veterans Intervention and Prevention Program. He did have substance abuse problems, and clients have addressed those problems, have been thwarted by the defense. And so for those reasons, Your Honor, state's position is that he's shown that he doesn't want to be on probation, and the court should sentence him to corrections for a period of no less than 5 years.
All right, and defense, what are you requesting?
Two things, Judge, if I may address a couple of things. We're going to respectfully request that you continue him, a couple of things about the Veteran Intervention Program. And he actually was signed up for that back in April. Went to a couple of classes. He was having trouble communicating with his probation department. I showed emails to the state of Texas about that we weren't, I wasn't lying about just probation department just stopped communicating with him after a certain date. So he freaked out and said, I'm not gonna do it. He was arrested, and before this court, I was appointed 2 weeks ago. He made bond. Since then, he got out. He has signed up for the Veteran Intervention Program, and he's set for his first class on Thursday.
So why hasn't he followed the court's instruction with regards to felony drug court?
Well, I'm gonna get to that. I'll
Okay.
go one at a time.
All right, I like the one at a time.
He did speak with the probation officer, and she did say that she would make attempts to. That's like.
The drug court. The drug court also, Judge, he was notified, and this is through a series of emails from the state of Texas that we've shared all this stuff together already. And so we're trying to give it in a nutshell. On 4/22/24, he did not qualify for drug court. Now, since that time, they still asked him to come to the court, I guess, to tell him you don't qualify, what have you. On 4/25, he had called up his probation officer and told them, listen, I've been in the hospital. And they said, well, unless you show us some kind of proof that you're in the hospital, we don't care. As of today, I don't have it printed out, but I did see it, Judge, and there's an office court on the town. He was in Methodist Hospital from 4/27 to 4/29, which lacks it was the 25th is the day we're talking about, so that's 2 days. However, I'm speaking with him and his wife. He was sick on the 25th. They had gone to Mission Trails first, which is the
All right, so
hospital that
let's-
transferred. So anyway, so the drug court, he
What
didn't
about the
qualify.
19th, April 19th? Because on April 19th, it says that he failed to submit for an evaluation for placement in drug court.
From my understanding, but that was, it even goes back further than that, Judge. I think that the train of emails go back further than that. About the dates of what was happening and dates being moved.
All right, I need to
So-
see that, because otherwise I'm thinking he would need to go to prison, but I want to see the email in regards to April 19th.
Well, there's gonna be a trail of emails, because
Yes.
they start like all the way back in April.
It's the case codes for the drug court supervision officer.
Right, so if I could see those.
And then the TAP judge, other than the TAP, again, we're taking full responsibility of the TAP because we don't want to do that. But at the end of the day, when it came to the TAP and talking to the probation officer, he was told that they were really backed up and that he'd be notified later on, and he was never notified.
Let me ask you
later on.
this, and if your client is drug tested today, is he still going to be positive for marijuana?
He should be clean, Judge, and that was gonna be my second option, Judge. I know there's been a history of the marijuana.
Mhm.
We go back and look at it too, and in fact, when he was back in front of this court, he had just got in or just got out of jail, so he had this, but he's been clean for a month. And that reminds me of something else. He's been going to AA meetings since April of 2024. And I did get a letter from his AA sponsor who says he does AA every Friday. He's been doing it every Friday for the past since April of 2024. In the alternative, I know the probation had asked for, and we are in agreement, should the court decide not to continue him out on the streets, probation is asking for Saturday.
He's saying it's safety.
Oh, I'm sorry, safety. Yeah,
All right, here's my question. Has he done a TAP evaluation? Because in the motion to revoke, it says no TAP done.
I don't think a tap has ever been done.
And does anybody have the court summary?
I have one.
Any objections to the court reviewing?
Not for the facts.
All right, so this is one of my questions from reviewing the court summary. So it says that he claimed that he was already enrolled in BIP with CPS. So I'm assuming that's not true.
Judge, you'll have to, I don't know that answer.
All right, Jenna, raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Happy Salazar?
All right, so in the court summary, it states that you told them that you had enrolled in BIP with CPS. So is that true or no?
Yes, ma'am. I already did the, I was enrolled with the BIP, but I got incarcerated for CPS but I finished my parenting classes and all that for them.
No, BIP is something completely different from
Better
parenting.
intervention.
Yeah, it says on February 6, 2023, the probationer reports he enrolled in BIP with CPS. On March 10th, 2023, officer inquired about BIP and he started crying, states they are giving him the runaround. On April 12th, 2024, officer inquired about BIP and he stated he sent the packet and has not heard anything. On May 14th, 2024, the probationer called and states he called about the BIP and they told him the price. Officer informed him to register ASAP, and he states he will try and get the money soon. Officer received a call on June 11, 2024 from probation stating if his appointment to report should be rescheduled due to his daughter award ceremony. So the question becomes, did you enroll in BIP through CPS or no?
Yes, ma'am. I did, and then I was enrolled. I enrolled in,
I don't know about the CPS. I know he had enrolled in this was just
Any objection to me? Does anyone want a search warrant for the cell phone?
We're not gonna do that. We're not gonna do that. That may be, there's a couple of the things on there, Judge, that I need to,
All right.
if that's not. the
I
standard.
won't swipe.
No, that's.
Is this an Android or is this?
It's an Android.
All right, so then I know how to use it to.
There's
see.
actually two different phone numbers that a lot of this paperwork was texted to me on, Judge, and I'll be happy to kind of flip back and forth
Okay,
and give you.
all right. Is there anything else?
Not from the state.
Just, again, just a couple of last things, that goes to the allegations, Judge. He is he does work full-time. He works for Lone Star Mobile Home Installers. He transports mobile homes. He's a father of two. Actually a father of three, but he takes care of two full-time. And so we're respectfully requesting either to continue and let him work these issues, and if he can't do that, then probation's recommendation.
All right, so here's the thing. You're getting drug tested today. What are the results gonna be? And now's the time to tell me. If it's gonna be positive, now's the time to tell me.
I was in jail for the last about a month and I've been out clean. I didn't mess with anything when I got out of jail, man. I didn't do anything, smoke cigarettes. And last night I took NyQuil, that's about it, because I've been feeling sick.
See, so here's the thing. We're doing NyQuil, and the last time there was an issue with alcohol.
But I explained to him I'm sick. I did take it because I was sick last night.
Well, here's the thing. You're not supposed to be taking alcohol at all. Those are not my rules. That's the legislature's
Oh,
rule.
I didn't
You
realize.
can't drink alcohol at the house when you're on probation. Can't do marijuana in your house. Just not allowed.
Was Dayquil and NyQuil like for cough and congestion?
No, so you're not hearing me.
Yes, ma'am.
Let me ask you this. Do you read the label on that? Is there alcohol in that? Yes, there is. Dayquil, is there alcohol? Yes, there is. NyQuil, is there alcohol? Yes, there is. You're not allowed to take anything with alcohol in it.
Sorry, I was not aware of that. I'm sorry. I was just really
You
sick.
should have been aware
I thought
because
I
you
had
tested
COVID.
positive for alcohol before.
I thought I had COVID. It didn't feel good at all.
Well, NyQuil is not gonna help you with your COVID. I mean, I could be, I'm not a medical doctor.
Yes, ma'am.
I play one on TV, but
Yes, ma'am, but I have not changed any drugs or anything.
okay. All right. Anything else from either side?
Not from the state.
Upper fence.
Probation. So you all don't have a TAP evaluation on him. Am I correct in saying that?
Yes, ma'am, that's correct.
All right. Can we get an expedited TAP on him?
Let me send a check out to you.
Thank you, State. You may be excused. All right, let's do this. Just have a seat in the box. They're gonna tell me about this expedited test.
Thank you, Judge.
Are you all ready on Carlissa Johnson? And probation. Can you tell me the date for out of custody? And I don't want 3 weeks for out of custody. I'm thinking this week.
It's not, I don't think it's gonna happen. They're 3 months out on regular appointments now for TAP judge.
And what is it in custody?
In custody, should be able to do it within 2 weeks.
All right. All right, court is calling 2020 CR 11653, State versus Carlissa Johnson. Can I have parties announced for the record for the state
Rick Pena for the state of Texas.
defense?
Jim Wheat for the defense.
And are you Miss Johnson?
Yes, ma'am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Carlissa Denora Johnson who was placed on deferred adjudication in 2020 CR 11653 for the offense of criminal mischief, $2,500 to $30,000 on April 9, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Here, trying to review today on state's motion to enter adjudication of guilt and revoke community supervision. Violation of condition number 5. In Bear County, Texas, the defendant, for Lisa Lenora Johnson, the then and there failed to report, to and abandon all of the conditions.
Any objections?
No objections.
You understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There's no agreement, Judge.
State, what are you requesting?
You're requesting 2 years in state jail with credit for the time the family was served in custody.
Defense, what are you requesting?
Judge, we'd ask for you to take a look back at her file and at the reports from probation. She has tried and has not done all that well in treatment. But during that time, she has been locked up a good bit while working with the court. She also has 240 days. Well, I was told 240, it might be 190, somewhere in that range of the amount of time that she has. Given her history, given the fact that she has worked with the court at different times and looked to work with the court, we're asking only that you give her credit for her time served, which I believe is 190 days. And I know she would, I believe, would like to speak to that too.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Melissa Denora Johnson.
All right, what would you like to say?
Just that, with all this that I've been through, like mental health wise, I got back, stable on my, medications. I have learned my lesson. I have been in and out of trouble, but this time I actually stayed with the Center for Healthcare Services. I'm doing better, but I just hope that I can, you know, I don't know what I'm trying to say. I'm nervous.
Oh, that's okay. There's no need to be nervous. I'm just here to listen and hopefully make a just decision in what's right. What I can tell you is, what I want to know is what have you done since you've been on probation? So the violation of condition number 5 tells me that you haven't been reporting. And my understanding is that you were supposed to be at Pay It Forward. And I'm just saying that because your counsel asked me to look over your history. So were you at Pay It Forward? And if you were not, why not? That's a good program.
I wasn't paid for it. I actually finished, but I was let go a week early for my needs, like it was medical release. And I moved on to the sober living and I didn't stay there. I got flagged for not coming in on time and I just didn't stay. When they told me I had to wait 2 hours outside of for the sober living so I can come back in, I didn't stay. I just left. I didn't feel comfortable.
What do you mean you didn't feel comfortable?
I mean, just waiting there outside of the gate. That was one of the things that they do when you're late, when you
I mean,
get
those are
back.
called consequences, right?
Yes, ma'am.
Her family is here,
Mhm.
here in the back. She has a place to go if the court can allow her back out again. And we have that set up.
Well, what I can tell you is, I don't think a judgment satisfied is appropriate in this case. I don't think 2 years is appropriate in this case. You have done some things, but I'm not gonna give you a judgment satisfied.
Okay.
All right, so, is there anything else from either side?
191 days, Judge, would be fine.
Okay,
No.
yes, state,
Your Honor, Fisher was ordered to SATF on November 1st, 2021, but she failed to surrender at the Bear County Jail placement on December 9th, 2021. You allowed her to attend intensive outpatient treatment, but she failed to attend in August 2nd, 2022. There was a compliance hearing because of that, Your Honor. At the compliance hearing on October 25th, 2022, the defendant was ordered to complete a TAP evaluation, which recommended DDOP. But it did begin, that was in February 24th, 2023, but was discharged 3 months later on May 23rd, 2023. Her probation has already been extended and amended for 6 months to include PDRF. Entered PDRF November 8th, 2023, but was discharged March 4th, 2024 with recommendation for safety. And here we are, Your Honor, after all this time, and can't really help her with her probation anymore. That's why state's making a recommendation that it is.
Judge, just a reminder, she has never been arrested before this case. This is the first one in. You gave her deferred. She did not do well, and we're not trying to hold her up as somebody who was perfect on her probation. But the amount of time that she's been in is certainly commensurate with what we've seen in this court on some other cases. And I don't think that it's inappropriate to consider something in that 180 to 190 day range, especially with no prior history.
well, what I can tell everybody is, I treat people as human beings, so everybody's case is different. What I may have given, person A, I don't give the person B, because I'm treating people as individuals. All right, counsel, did you go over the trial court certification with her?
Let me have her sign it. All this means is that there's no plea bargain and you can appeal if you choose to.
Thank you.
No, you can say- so we wanted you to go.
All right, and reviewing the file, I did see that in October, your conditions were altered and amended, and you were admonished not to miss any more appointments. And that was me trying to get your attention, and it did not work. Okay. So as previously stated, the court is finding violation of condition number 5 true. The court is going to grant the motion, find you guilty. Court is going to sentence you to 18 months in the state jail facility. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes,
And did you sign it?
yes.
Counsel, I need the copy because
Oh.
you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Yeah. Can you just make a copy of this? All right, because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question of what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
And I will also request the therapeutic community. It doesn't increase the time that you're in custody, but they may be able to help you in regards to your rehabilitation. All right, good luck to you. Thank you.
Have a seat, ma'am. By your second chair.